Qatada's deportation demonstrates both our commitment to abide by the law and our resolve to deport foreign nationals who threaten our safety and security. It also demonstrates the legal validity of our policy of deportation with assurances. The deportation of Abu Qatada has taken 12 years and cost over £1.7 million in legal fees for both sides. That is not acceptable to the public, and it's not acceptable to me. We must make sure it never happens again. First, we have to do something about the legal fees spent by defendants and paid by the taxpayer, not to mention the benefits they also claim. Second, we have to remove the many layers of appeal that are available to foreign nationals we want to deport. And third, we have to do something about the crazy interpretation of our human rights laws. The government is taking action to address all three concerns. First, legal fees and benefits. In the case of Abu Qatada, £220,000 of his legal fees were actually funded from his own accounts, which were frozen by the authorities. But the rest, some £430,000, was funded by the taxpayer. And in many other cases, foreign nationals we ought to be able to remove have their legal costs paid in full by the public. That is something my Right Honourable friend, the Justice Secretary, is addressing in his reforms to the legal aid system. And I can also tell the House that my Right Honourable friend, the Secretary of State for Work and Pensions, is also looking at how we can curtail the benefits claims made by terror suspects and extremists whose behaviour is not conducive to the public good. Second, we need to do something about appeal rights. Through the Crime and Courts Act, the government has already legislated for the principle that in national security cases, individuals should only be able to appeal following deportation to their home country, except in cases where there is a risk of serious irreversible harm. But we will do more, and that is why we'll be introducing the immigration bill later this year. That bill will stop illegal immigrants accessing services to which they are not entitled. It will make it easier to remove foreign nationals. It will make it harder for them to prolong their stay with spurious appeals, and it will make clear to the courts once and for all that foreign nationals who commit serious crimes shall, other than in exceptional circumstances, be deported. And I hope honourable and right honourable members from all parties will give their support to that bill. I can also tell the House that my Right Honourable friend, the Justice Secretary, is looking at ways to speed up the pace at which the courts hear national security cases. But those reforms can only achieve so much until we make sense of our human rights laws. This government is already taking action to address the misinterpretation of Article 8 of the European Convention on Human Rights, the right to a private and family life. And we have achieved reforms to the way in which the European Court works in the Brighton Declaration. But the problems caused by the Human Rights Act and the European Court in Strasbourg remain. And we should remember that Qatada would have been deported long ago had the European Court not moved the goalposts by establishing new, unprecedented legal grounds upon which it blocked his deportation. I've made clear my views that in the end the Human Rights Act must be scrapped. We must also consider our relationship with the European Court very carefully, and I believe that all options, including withdrawing from the Convention altogether, should remain on the table. But, Mr. Speaker, those are issues that will have to wait for the general election. Today we should take quiet satisfaction that a dangerous man has been deported to face justice in his home country.
The Home Secretary has herself drawn on the Human Rights Act. She used it to prevent Gary McKinnon being deported from the US to the USA, and without the Human Rights Act she would have had no legal justification for doing so. It is unclear whether she wants no Bill of Rights at all, with the consequence of little restriction then on what the Home Secretary's decisions can be, but can she also confirm that the government's own commission on a draft British Bill of Rights in fact replicates Article 3 of the Human Rights Act, the absolute prohibition on torture? And as she knows, the central issue in the Abu Qatada case has always been about torture, something we in Britain have always abhorred. So ditching the Human Rights Act and replacing it with her British Bill of Rights in this case would have made no difference. She also made much in her statement of the importance for us as a civilised nation of not acting outside the law. But what kind of signal would it send if we resiled from the European Convention to other countries where we try to persuade them to adopt higher standards of human rights and to follow the European Convention, including Russia over the criminal justice system, or Turkey over the treatment of Kurds. Mr. Speaker, the work that the government has done in the Abu Qatada case is immensely important. Deporting a dangerous man, delivering new legal deportation agreements so we can remove people to Jordan and elsewhere, new protection against torture in Jordan, and showing the British government's determination to pursue what is right whilst respecting the rule of law and holding no truck with torture either. All things she rightly claimed credit for in her statement. Reforms are needed to deal with the problems in this case. We are pleased that Abu Qatada has finally been deported, but we cannot have these kinds of delays in future. But she should put forward these reforms without ripping up the things she has just achieved.